The term genocide is very contemporary, only first used in the 1940s when the concept entered international law. However, the phenomena probably dates back to prehistory. During the 20th century, human beings became increasingly adept at waging war and mass atrocities. The earlier outrages of slavery and colonialism were replaced by ever-efficient brutal dictatorships and divisive political movements. In our own time, genocide has often featured in the news. This presentation seeks to examine the origins of the concept, detail its legal definition, and show its significance, and look at other possible legal measures that could further protect human rights. Legal scholar Raphael Lemkin first defined the concept of genocide. Because he was a Polish Jew, many assume he was referring to the Holocaust. However, his research was on the Armenian genocide, which occurred during the First World War. Here's an early CBS interview on this topic.
Genocide is a new word combining the Greek word genos meaning race or group, with the root of the Latin sidere meaning to kill. Dr. Raphael Lemkin, who is a professor of law at Yale University and specializing in teaching matters about the United Nations. Dr. Lemkin is the man who created the word genocide. Dr. Lemkin, could you give us a little background on how you came to be interested in this genocide?
Became interested in genocide because it happened so many times. It happened to the Armenians, and after the Armenians, Hitler took action.
Lemkin became the leading force behind the drafting and adoption of the International Convention on the Prevention and Punishment of the Crime of Genocide, adopted unanimously by the United Nations General Assembly in Paris on December 9, 1948.
Nevertheless, for many, the Holocaust is the definitive genocide. Following the defeat of the Axis powers in the Second World War, military tribunals were set up, most famously in Nuremberg, but also in Tokyo, where they tried many war criminals, including Hermann Goering, Albert Speer, Rudolf Hess, and Japanese Prime Minister Hideki Tojo. The term genocide was used at these trials, but it had not yet had a legal definition. So these major Axis figures were tried for war crimes and crimes against humanity. War crimes are grave breaches of the four Geneva Conventions. Signed in 1864, the first Geneva Convention covers wounded and ill combatants. The second Geneva Convention, signed in 1907, covers combatants at sea who are wounded, ill, or shipwrecked. The third Geneva Convention, signed in 1929, covers prisoners of war. It contains the famous statement that prisoners are only required to turn over their name, ranks, and serial numbers. Furthermore, it notes that prisoners should not be considered hostages. Finally, the Fourth Geneva Convention in 1949 covers civilians. These agreements only cover crimes which occur in wartime. It took many years before the United Nations recognized crimes of aggression or crimes which cause wars. Over many years, crimes against humanity were recognized. They eventually were enumerated as 15 serious violations. These can occur against civilian populations either in wartime or peace. The listing you see here is quoted from the Rome Statute establishing the International Criminal Court. Violations can include murder, extermination, enslavement, deportation, forcible transfers of population, imprisonment or other severe deprivation of physical liberty, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, persecution against any identifiable group, the enforced disappearance of persons, apartheid, segregation, and other acts regarded as inhumane. The Convention on the Prevention and Punishment of the Crime of Genocide, which I mentioned earlier, is divided into 19 articles. I will be looking at the first 5. Article 2 precisely defines this crime as meaning any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group. These include, in declining order of severity, killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. While we typically think of genocide as mass murder, in fact, points D and E involve eliminating a group without killing anyone. Selected compulsory sterilizations in Indira Gandhi's India is an example of D. An example of point E is a long-standing case in Australia in which Aboriginal groups have opposed the historic policies of Australian governments transferring their children to white families. The key factor proving a case of genocide is the showing of intent. Article 3 enumerates the acts which are punishable under the Convention. They include genocide, conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. Genocide does not need to be a completed act. There's no such thing as attempted genocide. An attempt to commit genocide is genocide. Wisely, the framers of the convention chose this wording in order to give the convention force and not to allow a group to be eliminated before action could be taken. This is a rather unique crime. In order to be convicted of murder, someone needs to kill someone. In order to be convicted of robbery, someone needs to steal. But in order to be convicted of genocide, one only needs to attempt it. Article 3, point C, is particularly interesting because the direct and public incitement to commit genocide can include many things. The charter of Hamas, hateful statements made by Israeli settler groups, and even chants of American university protesters. This creates a legal quandary in which national laws conflict with international agreements. To use the United States as an example, the supreme law in the United States is the U.S. Constitution. However, second in the hierarchy of laws are international agreements and treaties. These are of more importance than any federal, state, or local legislation. It remains to be decided whether constitutionally protected rights trump international provisions. Freedom of speech is never absolute. However, the Genocide Convention has never been cited to counter hate speech. This is not unique to the United States. There's hardly a country in the world in which national laws do not conflict with international agreements. Article 4 importantly notes, persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutional responsible rulers, public officials, or private individuals. Clearly, this was meant to prosecute individuals, as was the case in the tribunals which were held for former Yugoslavia and Rwanda. One of the unfortunate aspects of the South African case against Israel is that Israel is collectively punished, which flies in the face of the whole spirit of the convention. It would have been much more appropriate if this case had been presented against individuals at the International Criminal Court as opposed to the whole of Israel at the International Court of Justice. Article 5 mandates that all signatories to the convention should incorporate it into their constitutions and legislation. You may have noticed I skipped over Article 1. Article 1 is powerfully worded. The contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and punish. This is an escape clause that has been unfortunately used by many governments, including the Clinton administration, which avoided intervening in Rwanda. Similarly, the situation in Srebrenica in Bosnia was not declared a genocide until 10 years after it had happened. Those wishing to avoid involvement only need to avoid calling a situation a genocide. When faced with national concerns, governments, groups, and individuals frequently ignore international law. Genocide is particularly difficult to prove legally. Some progress has been made with the cases of Bosnia and Rwanda. However, international law needs to reach beyond the difficulties it currently faces. Here are some thoughts on how we can proceed to stem atrocities without denying the intended significance of the whole idea of genocide. Historically, population removals have been used to clarify ethnic lines. Following a period of intense conflict after the First World War, Greece and Turkey agreed to exchange populations. 1.5 million Greeks were removed from Turkey, and 500,000 Turks were removed from Greece. While memories of this are very bitter, Greece and Turkey never had another major war. A more severe example of population removal occurred following the Second World War, when over 11 million Germans and more than 5 million Poles were moved at the behest of the Soviet Union. The animated map in the lower right corner shows how German populations were shifted westwards. While population removals are never desirable, they do clarify ethnic lines. However, this proved to be impossible in the checkerboard of ethnic relations that was Yugoslavia when it broke up in the 1990s. Ethnic cleansing was a term often used in the Balkans. You can see it in its Croatian form here. However, during the demise of Yugoslavia, it became a popularized media term. A UN commission of experts investigating human rights violations in former Yugoslavia issued a report which defined ethnic cleansing as rendering an area ethnically homogeneous by using force or intimidation to remove persons of given groups. They further defined the concept as a purposeful policy designed by one ethnic or religious group to remove by violent and terror-inspiring means the civilian population of another ethnic or religious group. Many investigators, scholars, and jurists would later point out that the targeted groups were often seen as undesirable. Unfortunately, the Commission of Experts blurred the distinction between ethnic cleansing and other crimes by saying that it was covered by crimes against humanity, war crimes, and the Genocide Convention. Therefore, it had no separate legal definition. However, I strongly feel it should be a separate crime. One case that I would argue meets the definition of ethnic cleansing, but not necessarily genocide, is that of the western Sudanese region of Darfur, where people have been moved to deny them of their assets rather than to exterminate them. Darfur is a case in point of how human rights issues need to be pursued legally and dispassionately in the absence of any legal definition for ethnic cleansing. It would be better if this case were pursued as crimes against humanity. The term ethnic cleansing has been used in many imprecise ways, including hateful ones. A white supremacist group issued a video game called Ethnic Cleansing, in which a race war is conducted by white supremacists shooting blacks and Latinos, going down into the subways and eventually uncovering a bunker where a cabal of Jews is controlling the world. A British cowboy and Indian playset is confusingly called both ethnic cleansing and genocidal. Is urban gentrification ethnic cleansing? Is abortion ethnic cleansing? Much greater definition is required. I'm not suggesting we eliminate the crime of genocide. However, it needs to be reserved for those who proudly are willing to admit what they have done. Legally defining ethnic cleansing would allow cases to be pursued on the basis of measurable behaviors rather than on the high standard of intent required to prove genocide. We live in politically charged times. Human rights issues are often seen as just left-wing. However, this is not always the case. America's national parks were established largely based on the ideas of progressive John Muir, who envisioned a pristine wilderness devoid of human habitation. This led to a massive expulsion of all Native American groups from federal lands, a clear case of ethnic cleansing. We all like to see evil confronted. However, things are never quite that simple. The brutalized oppressors of one era often feel compelled to become perpetrators of inhumanity in another. Time and time again, we have seen this dynamic repeated in Germany, Cambodia, Bosnia, and Rwanda. We need to replace retribution with healing.